under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Have you been before me?
No, never.
I don't think you have. I need a spelling of your name. My recorder asked.
Malaika. First name, last name Fatima.
I told you. And where are you from?
I'm originally from Canada, but I'm in the dual JD program at Detroit Mercy and Windsor Law.
Canada, what part?
Toronto.
Toronto. One of my favorite cities. Where'd you go to undergrad?
I went to Toronto Metropolitan University.
Well, hearing no objection, permission to practice is granted.
Thank you, Your Honor. We do not believe that there is any conflict between this honorable court and our office, and if any conflict were to arise, we waive that conflict so that this honorable court can hear our matters.
The court, for its part, also does not believe that there is conflict. That is, the court rules of the cases decided thereunder. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. The court does call the case People of the State of Michigan versus Anitra Comer.
Richard McDuff for the people.
Student attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Stephanie Cannon on behalf of Ms. Comer.
Permission to practice is granted.
Thank you so much, Your Honor.
Ms. Comer, can you state your name, please?
Anitra Comer.
All right, thank you. Yes, okay, and what are we doing on this?
Your Honor, we are requesting to adjourn for 2 weeks so that we can have a client consultation in person with Ms. Comer at the Women's Correctional Facility.
All right. Is 2 weeks going to be enough to work through the process? I
I believe so.
think so. All right. 2 weeks notice. What?
Thank you.
Probable cause conference in this matter will be adjourned to June 26, 2025, 9 a.m. Bond will continue. Thank you.
Thank you.
Court does call the case of the people versus Aiden Evans.
Elliot on behalf of the people, Your Honor.
Morning, Your Honor. Chris Eastup appearing on behalf and with Aiden Evans, who is present. Mr. Evans, you step up and state your name for the record.
My name is Aiden Evans.
I have a plea form in front of me. Is that what we're doing today?
It is, Your Honor.
The plea form indicates that the defendant will be pleading guilty to the charge of illegal entry, the 90-day offense. Upon the successful plea to that charge, count one would be dismissed, and that the parties agree to sentencing under HIDA. Of course, the court can't bind the sentencing judge. Right. All right.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got.
Yes, sir.
State your name.
Aiden Jack Evans.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal entry. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Parole, Your Honor.
No.
Oh, no.
That's bond.
Parole?
Bond.
Bond.
Okay.
That's how new he is.
Yes. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Correct.
Yes.
Yes.
And because you believe that you're guilty of this offense?
Yes.
May 25th, 2025, at the location of 1043 North Main Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I entered the premise without permission from the resident.
So you entered somebody's house,
Yes, Your Honor.
apartment, and you didn't have their permission to enter those premises,
Yes.
and you had no property interest or other thing in that property. Now, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
That's satisfied.
Court will accept the defendant's plea of guilty to count 2 Count one is dismissed. Pre-sentence investigation and report is ordered at the district court probation. Sentencing will be
July 1st at 9 a.m. for Judge Mello.
July 1st, 2025, 9 a.m. before Judge Mello. On with its conditions will continue.
Thank you, Your Honor.
Thank you.
Do we still having them check out at the window after plea, or do they just get their stuff? They make up their own?
I don't. No. They should always check out according to Dan.
Thank you very much.
Really?
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green. Thank you.
Hello. Thank you.
To our arraignments. Mr. Green?
Yes.
I have, you're here on one case. I have two other cases where you need to be arraigned on those cases. And so we'll go through that process if they put my paperwork. Starting first with the case 25 F5 5605. In that case, sir, the complaint alleges that on or about May 3rd, 2024, at the location of 225 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, that you did commit the offense of uttering and publishing. Do you understand the nature of that charge, sir? All right. That is a felony punishable by up to 14 years incarceration. You understand that, sir?
Yes.
All right. On the other matter, the case ending in 600, in that case, if I can find the complaint here. That complaint alleges that between the dates of April 10th, 2024 and April 11th, 2024, at the location of 423 East Duncan Street in Manchester, Washtenaw County, State of Michigan, that count one alleges that you did steal or retain without consent a financial transaction device. Do you understand the nature of that charge? That is a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes.
Count two alleges the offense of breaking and entering a vehicle with the intent to steal property less than $200. You understand that charge, sir?
Yes.
All right. There is a second or subsequent offense notice, which makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property stolen. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
All right. These are public defenders.
Your Honor, regarding both arraignments, we waive formal readings, stand mute to the charges. And I'm sorry.
Go ahead.
On all three cases, I'd request a pretrial date.
Probable cause conference.
I'm sorry. Probable cause conference. Yes.
All right. You waive time limits.
Yes, Your Honor.
And you're asking for an adjournment on the other one.
Yes, he's going to be in Livingston, I believe, until September 30th.
Got it.
And we just want to review everything together and see what happens. Obviously, these are new cases.
All right. On these cases, I will adjourn the one case and set the probable cause conference for June 26, 2025 at 9 a.m. All right. And I'll get to the bond issue. Let's start with the Ann Arbor case first. Anything you want to say regarding the bond?
No, Your Honor, I just asked for a nominal bond. As I said, Mr. Green is going to be in Livingston County until the end of September.
Anything from the people?
Your Honor, on the, pardon me, on both of them cases, we requested a surety bond of $7,500. And with the reasons explained below, there's a no go-to request on this file for the DFCU financial branch at 25 Briarwood Circle. And I don't believe there's any no contact. That's the only other condition outside of the normal bond conditions on this file.
I'll indicate he's not to go to 225 Briarwood Circle on that case. I will set his bond at a $5,000 10% bond. I don't know that there's a necessity to have a cash or surety on this case. I will order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol possession of no alcohol consumption or possession. Also, that applies for recreational marijuana and no illegal drug. Dated, I said 6/26.
Yes, sir.
On the other matter,
there is a request for no contact with Susan Furda, F-U-R-D-A, as she is a victim in this case. I also requested a no-go to, actually within a 1 mile radius of 423 East Duncan Street in Manchester, as this was a case of break-ins with multiple homes in that neighborhood.
how was her last name spelled?
F-U-R-D-A.
No objection to that, Your Honor.
Bond in this case will be set as a $5,000, 10% bond. It'll indicate that there's to be no contact with Furda, and he's not to enter the township of Manchester. Anything else on that?
That no-go to as well on that file?
He's not to enter the township of Manchester.
Oh, okay, I didn't hear you. Thank you.
Nothing else for me, Your Honor.
All right. Thank you. Thank you, sir.
We'll be in touch, Mr. Green.
Permission to practice is granted.
Thank you, Your Honor. Christina Berry, for the people.
Good morning, Your Honor. Edward Drukas for Mary Collings this morning. I'm standing in for the attorney record of Kyle Burdell. I have a substitution form for the court that's signed. Not in the file, but will. And this morning I'm asking for an adjournment. I understand the discovery got sent over yesterday. Still need some time to go over that. I don't know if there's any outstanding discovery. I'd ask for an adjournment at the court's discretion.
Objection, probable cause conference will be adjourned to June 17th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Okay, thank you.
Thank you.
Good morning, Your Honor. Ken Madadish on behalf of Ms. Henderson, who is appearing by Zoom. Ms. Henderson, can you please state your name for the record?
Hardine Henderson.
Thank you.
You're welcome.
Yes, Your Honor. We are going to refer her to our AIM division and to continue plea negotiations with the prosecutor's office.
How long is she going to be in Wayne County Jail? Does she know?
A while. I believe they're doing a competency report there, so it's going to take a minute.
So
we can adjourn it out.
So there's a comp on her case there?
There, yes. I'm debating whether I need to talk to
Counsel approach.
the seniors in our office.
Counsel approach.
Yeah.
Or you can keep talking. Counsel approach.
Oh, counsel approach.
Okay. On this case, what I will do is I'll adjourn the probable cause conference, understanding that I may get a request for a competency or forensic evaluation to coincide with the one in Wayne County, but I'll adjourn this to, we'll just do July 10th initially, and then we'll see where we are.
Thank you, Your Honor.
July 10th, 2025, 9 a.m. On continue.
Thank you.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Aaron Fromm.
And Your Honor, we're just requesting a brief adjournment to review discovery.
Probable cause conference will be June 17th, 2025, 9 a.m. That's Tuesday. Bond will continue.
Thank you, Your Honor.
Good day, sir.
Okay. Janaza.
We're going to grab it right now, Your Honor.
Really? Ma'am, state your name.
Well, Michelle.
Thank you. Where is she? Somebody needs to get her in here or have somebody that can cover this case now. Thank you, Mr. Gaddy.
Morning, Judge Mike Gaddy on behalf of Ms. Harvey. You spoken?
Yes.
What's gonna happen?
So, we was gonna talk about somebody that I hit.
Okay, no, did she tell you whether the case was gonna go to?
Yeah.
Did she say she was gonna adjourn it?
No.
Yeah, I think this may be a referral.
Parental.
Yes, Your Honor, I'm trying to.
She told me that I'm here about a case about putting my hands on an officer at the correctional facility.
Okay.
That's what I'm here for today.
Yeah, Your Honor, we're going to refer this for competency. I'll prepare the competency referral and the, criminal responsibility referral forthwith.
Forensic evaluation is ordered. I'll set a competency hearing for 90
August 28th.
90? Okay. Say it again.
August 28th.
August 28th, 2025,
Thank you.
9 a.m.
Thank you, Your Honor.
Have a court date August 28th,
Bond will
2009?
continue.
Yes,
What month is this? June?
this is June, yes.
It comes after June.
Well, I'll come visit you in the back, okay? July comes after June.
Your Honor, good morning. Joe Simon on behalf of Mr. Tingley, who should be by Zoom.
I am Charles Tingley.
Okay, I'll need a camera.
It's just here.
All right, there he is. Okay.
Your Honor, I'm informed that the long-awaited contract with Detective Babbage in the county has been signed. And we are asking the court to grant our request for another adjournment. We're trying to be one of the first cases in line since we've been waiting, but I can't assure you of that. So
What's the anticipated time frame?
well,
The only information I have is that I believe the contract has been signed, and so he's gonna start scheduling them.
Got it.
So maybe 3 weeks, if that's.
unfortunately, I'll be gone at that time. So, but
Beautiful. We'll set it then.
thank you, Your Honor. Very kind.
No, I want you around because you're around and Miss Landy's there. We learn things.
We do further our education. That is true.
I'm so full of that. I am. It's a joyous time when you learn things.
It is.
So
That is true.
what date do you want?
Your Honor, could we possibly go to July 10?
Is there any objection from the people? Probable cause conference, July 10, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Your name?
Molly Fox.
All right, what are we doing?
Well, Your Honor, this is a PCC conference, and we've had many adjournments, but what I would like to see happen today is that the court would reinstate Ms. Fox's bond and let her get out. And I would say that Jacob Kennedy and I have had many discussions about resolution here, but we haven't really come to a conclusion. And he sent me the paperwork on the recovery court, which I discussed with Molly Fox. I went to visit her on Sunday and talked to her about it. And we went through some of the responsibilities and what would be expected of her if she was to be accepted in such a court. I believe that she could do that, but only if she has strong family support. So I urged her what I would like is for her to get out so that she can talk to the family members, which are, in my opinion, their involvement and support is absolutely essential for her to be able to complete the recovery court program. The other matter is we have never really come to a conclusion as to what the plea would be if she were to go into the recovery court. So I would like to have an adjournment of the PCC, but I also would like to have her released again on bond so that she can do these things and come to some kind of conclusion.
Well,
I thought he was.
Stop using cocaine.
Well, of course she does. Absolutely. And she, she did complete the first 8 weeks successfully of the Dawn Farm program. She doesn't, that's the other thing. She doesn't know whether they would let her back into the program or They should actually be able to re-enroll.
Okay, so what do you want me to do with, you want this adjourned?
Well, yes, but I wanted to be adjourned with a release of her from custody and go back on the bond if possible. Because she's had
Okay,
kind of.
I don't negotiate that way, but that's okay. I don't know that I'll release her. I don't know what you want me to do.
Well, as I did make out an adjournment paper.
Do people have a position on bond?
Yes, Your Honor. At this case, involved a situation where the defendant was intoxicated. That's why she failed the test. And then while she was caught, I don't think that a release is appropriate without a treatment plan in place, which there is not.
Well, I'm informed that the Dawn Farm program would let her back in. I don't know for sure. I can't represent to the court that that's possible, but she seems to think it is. And that's a pretty, I mean, she was attending AANA once or twice a week. She was doing a group program, and she did that for 8 weeks successfully. And then, she had the incident where she used cocaine again.
2 incidents.
2 incidents, sorry.
Yeah. Probably more because there's a lot of abnormal creatinine. She was using. So the issue from the court standpoint is this. I am not going to release her or change her bond until there's something in place so that she's at least receiving some treatment or something along those lines or some program. It's not going to happen. Give you time to put that in place, or to try to figure out what that's going to be. And I'd suggest that you talk with the prosecutor's office and try to work something out that is structured for this individual. So your motion for bond modification is denied. I will adjourn this matter to June 26, 2025, 9 a.m.
Your Honor, just for my own information, if I were able to determine that the Dawn program would let her back in or let her restart or whatever, would that suffice from the court's point of view?
Here's what I'd suggest. If you were to confirm that there would be something in place for her treatment, I'd suggest that you get with the prosecutor's office, see if the two of you can come to some type of an agreement. If you can file a motion, I'll hear it, or we'll hear it on the 26th. Okay?
Thank you, Your Honor.
Thank you.
Good morning, Your Honor. Wendy Burnwell standing in for the attorney of record, Kareem Johnson.
Your name, sir?
Christopher Gilmore. Good morning, Your Honor.
Good morning. And you have no objection to Barnwell stepping in?
No, sir.
All right. All right. What are we doing?
Mr. Johnson has indicated that he received all discovery and he wishes to set exam dates on both cases.
People have the witnesses available on the 17th.
Whereabouts, Your Honor?
You said June 17, Judge?
Yes, sir. Yes, ma'am. Preliminary examination in these matters in person, June 17th, 2025, 9 a.m. That is before Judge Moore.
Your Honor, there's an ongoing discussion because my client wishes, Mr. Johnson's client wishes to have permission to leave the state. However, I'm indicating to him that the court would want that in writing. And the court would want
What's
defense
his
counsel.
purpose for leaving the state?
Right.
I'm about to turn a new leaf, Your Honor.
Pardon?
Can't just, the case has to be resolved.
All right.
You just want to leave the state?
Yeah, I'm tired of getting in trouble. My summer, I don't want to spend my.
You don't like the great mittens of the north? Go ahead. You just want to leave the state while criminal charges are pending? Probably is not going to happen.
All right, thank you so much.
Yep. Okay. Great. That's glad we're.
Can't do it.
Thank
I
you.
have a good one. Yeah.
James Fifelski appearing on behalf of Mr. Sullivan, who is approaching. Can you state your name for the judge, please?
Marvin Sullivan.
Your Honor, at this time, we will ask the court to set this for preliminary
All
examination.
discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
Is it any way possible to go 1 week to the 24th? And I will represent the court. I understand that Mr. Sullivan has a hearing in front of Judge Conlon on an extradition on the 25th. So I don't think this would be holding him any longer than he on this case that he would be otherwise.
I'll leave it to the court's discretion.
Preliminary examination in person, June 24th, 2025, 9 a.m. before Judge. Fresh hour.
Under the supervision of APD Stephanie Cannon, on behalf of Mr. Bounds. Mr. Bounds, could you state your name for the court?
Alexander Bounds.
Your Honor, we're requesting that the court set a date for Mr. Bounds' preliminary exam.
All discovery is complete.
Yes.
People have their witnesses available the 17th. Preliminary examination in person, June 17th, 2025, 9 a.m. Actually, that's at 12 noon. That is before me.
Thank you, Your Honor.
Bond continued. Thank you, sir. That's in person. Court does call the case of the people versus Elliot Khazan.
Ready, Your Honor.
Castellani for the people.
Oh, you're still here.
I return, Your Honor.
Oh. Picking up knowledge. I'm sorry.
Joe Simon on behalf of Mr. Khazan. Your Honor.
Your name, sir?
Elliot Khazan.
Thank you.
Your Honor, I may request approach the bench, but I'm a little afraid. The last time we were here, we were about ready to enter a plea. Then we had our bond issue. The people have maintained the offer. My client wants to accept it. But could we approach briefly?
Yes, you can.
Thank you.
Oh, it's both you two.
Yeah, that's all. And to be clear, Your Honor, my client did fill out previously an advice of rights form that I
Wait, that was riding lawnmowers.
Go
ahead.
I'm sorry, Your Honor. My client did previously fill out an advice of rights form, but I re-reviewed that with him. And he knows that he previously filled out a sentencing judge waiver, but he also knows, I've reviewed that with him as well. Please write it in his please.
All right. The plea form in this case indicates that the defendant will be pleading to 3 charges. That he will be pleading to the possession of a firearm under the influence, the actual stated count 3, as well as an addition, and that's the 93-day misdemeanor. He will be pleading also to operating while visibly impaired first, a 93-day misdemeanor. And will be pleading to attempted possession of a loaded firearm in a motor vehicle. And I believe that's a 1 year. It's not on.
That is a 1 year, Your Honor, and I do believe
That's 1 year. Fines on that are,
1,000.
yeah, I think so. I think that's right. All right. And then counts 1 and 2 would be dismissed. And
The people are agreeing at the time of sentencing not to.
no upfront jail if defendant remains compliant.
Correct.
Okay. All right. May I have it sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name.
Elliot Khazan.
All right, sir. It is this court's understanding that you are going to be pleading guilty to 3 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
All right. First charge is a stated count 3 of possession of a firearm under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 to $500 fine plus court costs if you are using and or discharging the firearm. Also mandatory forfeiture of the weapon or device. You understand that?
Yes, Your Honor.
All right. Also, this court's understanding you're going to plead guilty to the charge of operating while visibly impaired first offense. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. Court could order rehabilitative services or any community service support deems necessary. Court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Also, count 5 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that? And also mandatory forfeiture of the device. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
All right. To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
To the charge of attempted possession of a firearm in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form previously, is that correct?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today in the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
June 22nd, 2023, at the location of Jackson Road near Stabler Road, Scioto Township, Washtenaw County, State of Michigan, Were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much, if you recall?
5 to 6 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police,
Why'd they stop you?
rolling through a stop sign.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the station or hospital for a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.095 blood alcohol level.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
In that motor vehicle that you were driving, did you have a firearm in it?
Yes, Your Honor.
And where was it?
In the glove box.
All right. And did you have authority to carry that firearm in that fashion in that?
No, Your Honor.
And I think that's and at the time you were under the influence and you had possession of that firearm.
Yes, Your Honor.
Counsel?
Was the firearm loaded?
No, Your Honor.
Well, actually, what?
Yes, it actually.
Okay.
Yeah.
Was
Yes,
the
Your Honor.
firearm loaded?
Yes, I had, yes.
All right.
In the magazine, not the chamber.
Yes. In the magazine, not the chamber. Yes.
But nevertheless, that constitutes.
Yeah. Same, yeah.
All right. Now, counsel, have I complied with the court?
I'm satisfied, Your Honor. Thank you.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be, we're on the wrong thing. Yeah. Give me that sentencing date again.
June 16th.
Sentencing, June 16, 2025, 9 a.m. Judge Fresh Hour. All right, Esteban.
Your Honor, we are requesting the court reinstate my client's bond. His original bond was 5,000, personal recognizance 5,000. He was ordered to community corrections to participate in sober link testing. The last time we were here, we offered to switch from that to a scram tether. That's our request, is to reinstate bond with the scram alcohol tether.
Anything from the people?
Your Honor, the people's concern is that the defendant not be consuming, so a scram tether will accomplish that goal at this time.
I'll reinstate the defendant's previous bond condition. So he set his bond, $5,000 personal recognizance bond. The defendant is to be placed on a scram tether prior to his release. I will sign that order, and I know you're trying to work through that, so we'll sign it and make sure that it gets over there.
Thank you very much, Your Honor.
Thank you, Your Honor.
All right, thank you.
Thank you.
James Fifelski, appearing on behalf of James Sharp.
Mr. Sharp, can you state your name, please?
James Glenn Sharp, Your Honor.
Thank you, sir. What are we doing?
Your Honor, we're asking the court to set this for preliminary examination. Mr. Sharp does have sentencing on a federal case on June 17th. We'd ask the court to set it for the 24th.
Is all discovery complete?
Yes, Your Honor.
Would the people have their witnesses available on the 24th? Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you very much, Your Honor.
We'll continue. Thank you. People versus Jody Williams.
Ready, Your Honor.
Alexander, on behalf of the people, Your Honor.
You're just everywhere.
Pardon?
You're everywhere.
It's been tough. I'll get my steps in. Joe Simon on behalf of Ms. Williams. Jody, state your name.
Jody Williams.
Thank you.
Your Honor, we're asking the matter be set for preliminary exam. And because you always know I never cause trouble for the court, what is the earliest possible? Because my travel dates are both on successive Tuesdays. I'd like to have this sooner than the 24th if possible. I travel on the 24th and then on July 1st. So
so you want us to accommodate your scheduling?
If
On
possible.
everything.
If possible.
That's an arrogance I haven't seen in a long time. Will the 17th work for you?
Yes.
All right. So
Thank you.
Discovery is complete.
Yes.
Would the people have their witnesses available the 17th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, June 17th, 2025. 9 a.m. That is before Judge Moore.
Wait for me outside, okay? Thank you. Oops,
Bond will continue. Thank you.
thank you, Your Honor. I'll see you on the next docket on Zoom, but Your Honor, I will say this, it's always an uplifting experience.
Good morning, Your Honor. Wendy Burnwell on behalf of Mr. Wesley Yonda Brand.
All right. What are we doing? I think I have a conditional release
They're gonna address
violation.
violation because you made a call and they're describing all this allegedly.
We have 17 complete calls to the victim since he was arraigned, as well as 84 total attempt in so he's tried to call her a total of 84 times, with 17 of those calls getting through.
Counsel.
Your Honor, this
The
is,
bond violations. Why don't we start there?
Your Honor, this is, I didn't have enough time to talk to him about the particular alleged bond violation, Judge. I did read it yesterday. It was sent to me and I did read the bond violation.
And does he want it set for hearing? Or?
One
does
second,
he
Judge.
admit to the violation?
Yes, Judge.
What are we gonna do?
Wishes to set it for a hearing, Judge. I'm assuming it's another day.
Yes.
Okay.
Set a bond violation hearing. Gonna have room on 12th.
Yes.
So I'll adjourn the probable cause and set a bond violation hearing for June 12th, 2025
Split second,
at
Judge.
3 p.m.
I'm here.
Pending that hearing, defendant.
I'm here, Judge. I'm here in front of this court that same day.
All right.
So
So that's at 3 p.m. And pending that hearing, defendant's phone privileges are hereby ordered revoked. His bond, however, is continued. Thank you.
I'm here, Assistant Public Defender Jay Bellinger, on behalf of Mr. Stewart, it sounds like. Derek Stewart.
He's here.
Okay. Thank you. And Your Honor, obviously, we haven't, our office has not had any time to review his police report with him and the evidence, so I.
Well, what is this set for? It's set for a confidence.
It's just on the bond.
It's here on the bond, on the bond, and you know nothing about those, I take it.
That's correct, Your Honor.
Is there a report? On this matter, the defendant is in custody on this case, I think, as well as others. He's awaiting a review hearing, which is set for July 22nd, 2025. Well, he wouldn't have been in. I think at this point, he's being held on this alleged bond violation, because otherwise it wouldn't have occurred that way. So at this point, what I will do is I'll continue the defendant's bond as being revoked for the violation pending a hearing on this. There's a report that needs to be prepared, as well as that, I've shown counsel the preliminary results, I guess, of the bond violation, which is possession of a weapon. So I'll set a bond violation hearing on this matter for June 26, 2025 at 3 p.m.
Thank you, Your Honor.
All right, thank you.
good morning, Your Honor. Wendy Barnwell, standing in for the attorney of record, Mr. Kareem Johnson, on behalf of Mr. Brooks.
Thank you, sir. Antoine Brooks. You have any Barnwell speaking? Yes. All right, what are we doing?
Your Honor, Mr. Johnson needs an in-person PCC on June 26th. He told me that's when he's available. He said, however, because he doesn't have all the discovery.
Oh, hold on. So he doesn't have the discovery. The 26th, he's just asking for an adjournment of the probable cause
PCC,
conference.
yeah.
Okay, thank you. probable cause conference will be then adjourned without objection, June 26, 2025, 9 a.m.
Thank you, Judge.
Bond continued. Thank you.
Good morning. This is Public Defender Lauren Penny on behalf of Mr. Branscombe. Mr. Branscombe, please state your name for the record.
Robert Branscombe.
Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, Your Honor.
Witnesses available the 17th.
I believe so, Your Honor.
Preliminary examination in person, June 17th, 2025 at
12 p.m. for judges.
12 p.m. That's before me.
Thank you, Your Honor.
Bond continued.
All right, thank you.
Thank you.
Your Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Alfredo Correjas.
Yeah, the wrong call. Seriously?
Your name for the record?
Anthony Alfaro, KS.
Got it. All right.
At this time, Your Honor, I'll be asking for a brief adjournment. He has another probable cause conference date scheduled with you next week on a new matter that is the basis for the other bond violation. So we were asking for the adjournment to be able to track those cases together.
He has a what?
A probable cause conference with you on June 12th.
On June 12th.
So next week. So we're just asking for that brief adjournment so the cases can track together.
And that case is what result. Oh,
Is what I believe is the other bond violation.
that's what I was trying to follow with what you had indicated. So
Yes,
we'll
sir.
deal with that bond violation. I'll grant the adjournment.
Thank you, Your Honor.
I'll adjourn this probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Mr. Bukovich, that went much better for you than last week.
It did.
Maybe it can continue.
That's the goal, Your Honor.
Kenma Dadish on behalf of Mr. Daughtery.
London daughter.
Two cases. What are you looking to do?
Your Honor, we are going to be adjourning. I believe we don't have discovery on one of the cases. So we're waiting to receive that from the prosecutor's office.
And I'm presuming that's on its way.
I believe it's the 1318, or one of the legal assistants or paralegals in our office emailed, I believe Tuesday, and then they looped you in and said, have you guys requested it? It's from a couple of years back, but we don't have discovery on one of them.
All right. Well, what I'll do is I'll adjourn probable cause conference June 26, 2025, 9 a.m. Let you guys try to get that cleared up. I see that the one is a 22 case, so sure they'll be able to find it, but all right.
Thank you.
We'll continue. Thank you, sir.
Thank you. Okay.
Court calls case People versus Jerome Burns.
Morning, Your Honor. And Assistant Prosecuting Attorney Babbitt.
And Assistant Public Defender Chinazi Kiriak and really, Your Honor, on behalf of Mr. Jerome Burns.
Nice of you to show up. Just thought I'd throw that out there.
I figured it was coming.
Mr. Burns, state your name for the record, please.
Jerome Burns. Thank you, sir. All right, what are we doing?
So, Your Honor, we are here for two matters today. I think we're doing a sentencing on the bond violation for Mr. Burns, as well as the probable cause conference. In regards to the probable cause conference, Judge, we are asking that this matter be respectfully set for preliminary examination.
You have all of the discovery.
To my knowledge, Judge, yes, we do.
We'll have the witnesses available to 7.
We'll do our best, Your Honor.
All right, why don't I do this? I'll set preliminary examination June 17th, 2009, 9 a.m. Or, well, why don't I do it this way? I'm going to set this one at 12 p.m. before me since it's on the other day. And I'll adjourn the sentencing on his bond violation to that same day.
Okay.
Bond will continue. Good morning.
Good morning.
What are we doing?
So, Your Honor, when we were here last time, I incorrectly filled out the plea form where I said that I was adding count 2 and dismissing count 1. And I meant to put I was adding count 3 and dismissing count 1 and 2. So that is why you're here today.
And it's also my bad because I didn't notice that on the plea form. So it's count 1 and 2 that are getting dismissed.
Got it. We're coming back just to correct the record. All right. What I will do then is I will sign sort of dismissing counts 1 and 2, accepting the defendant's plea to count 3, and then set the sentencing date. I'll set the sentencing date 7/10/25 at 10 a.m. before Judge Washington. And what I will do is I'm accepting the plea to count 3, non-protunct to May 22nd.
Do we need to turn in the form or not?
Yes, why don't you?
We don't need the advice of rights again, right?
You don't need that.
Okay. Thank you, Your Honor.
Good morning, Your Honor. Lauren Yaki, Assistant Public Defender, with and on behalf of Mr. Damon.
Good morning, Ms. Sharkey.
Good morning. Mr. Damon, could you state your name to the court?
Yes, Curtis Mitchell Damon.
Your Honor, I did fill out a green sheet. However, I am asking if this court would consider allowing Mr. Damon to be released to treatment. He is
Inpatient treatment?
to inpatient.
I'm going to have no objection to any order allowing somebody to release the treatment.
Okay, thank you, Your Honor. I think that will help immensely, and I know Mr. Damon is really serious about that.
All right.
Oh, and we would request an adjournment of the probable cause conference for him to get into treatment. I think that will help discussions with the prosecution about how to
Do
resolve.
they have a timing to try to get him there, or how's?
I don't have any specific update as to timing.
Well, why don't I do this, then I'll adjourn the probable cause conference to June 26, 2025, 9 a.m.
Thank you.
See what progress they make regarding. All right.
Thank you, Your Honor.
Thank you.
Because Mr. Damon's tether, they closed his file essentially because he absconded as far as the scram is concerned. What would be the status of that order? Would the court wait to see if
They closed it. They closed out his tether.
Yeah, we have a report from May 13th, I believe, where they had lost contact with Mr. Damon. He last reported for a scram download April 29th. And so where that particular tether might be located and whether we would need a new order depending on what happens with his treatment. He said he still has it.
And thank you, Ms. McDuffie, for bringing that up, because I actually, in the proposed order I drafted, I did put in all prior bond conditions remain in full force and effect. I didn't mention anything about the tether, so.
Okay, I'm just looking at it. That was a GPS tether.
Scram.
No, alcohol.
It was a scram tether?
Yes.
Yep.
Okay. So what I'm going to do is I'll just add it. I'm adding a sentence to the order I signed. He can be released to inpatient treatment program once a bed becomes available with a scram tether prior to release. Okay. So I'll add that, and I will also sign a new order for a scram tether. So that way, if a bed becomes available, he gets a scram tether. Okay.
Thank you, Your Honor.
And I'll set it for June 26, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
And Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Ms. Siobhan Benson. Hi, say your name to the record. My name is Siobhan Benson.
I'll find him here.
Get right behind you.
All right.
Your today is a time and date set.
Your name is?
Oh, my name is Siobhan Benson.
Thank you. All right, yes, go ahead.
Today is the time and date set for a competency hearing in all matters. And the people are in receipt of a report from Center for Forensic Psychiatry dated May 15th, 2027, authored by Candace Shield, PhD. And we would stipulate to the entry of that report and ask that the court make a finding.
Any other evidence for the defense?
I apologize, Your Honor. You asked if there was, Your Honor, we have had an opportunity to review the report as well. We are going to stipulate to the findings in the report, and as per the probable cause conference, Judge, we're asking for an adjournment as we continue our investigation.
All right. For the purposes of the competency, the defendant, based upon the review of the report, the defendant is competent, will be found competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her, of the charges against her, and can rationally assist in her defense. Therefore, the defendant is deemed. I will set a probable cause conference then. Would the 26th work for you?
We will make it work, Judge.
June 26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond will continue.
I also want to expose these people because they're lying on me. I'm not no demon. I'm not no monster. These people were hurting my daughter. They were sexually assaulting my child.
You'll have an opportunity.
It's too much. I'm not no demon. They hurt my baby and they're hiding this. They're covering it up. The state of Michigan is hiding and covering this up. They hurt my child.
Assistant Public Defender Natalie Pate on behalf of Mr. Kaba, who may be present via Zoom.
See him. You got a copy?
I do not. I have one unnamed individual client.
Lamine Kaba? No, I don't have it.
Your Honor, I do not have an explanation for his failure to appear. I was unsuccessful in reaching him between the last probable cause conference and today's date. I did also make attempts to contact his mother and left a voicemail with her as well as provided her with the Zoom information. I have no further explanation for his failure to appear and for the record would respectfully request an adjournment of this probable cause conference.
Bench warrant will issue for defendant's failure to bond is set in the amount of $10,000 cash assured. That warrant will issue. Let's call the case People versus Vincent Dunlap.
Public Defender Jay Bellinger, on behalf of Mr. Dunlap. Miss, can you please state your name for the record?
Vincent Dunlap.
Thank you. So what are we doing?
Your Honor, we are just asking to set this for preliminary examination today.
Discovery is complete.
Discovery is complete to the best of my knowledge.
We'll have the witnesses available the 17th.
We'll sure that's your.
All right. Preliminary examination in person, June 17th, 2025, 9 a.m. That's before Judge Moore. Bond
I'll
continues.
still be here, okay? 17th. All right? All right. Thank you.
Court calls case of the People versus Elia Keys.
Elliot on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Keys, who should be appearing via Zoom.
State your name, please.
Kiera Keys.
Thank you. All right, what are we doing?
At this time, Your Honor, we'll be setting this matter for preliminary exam. To my knowledge, all discovery is complete. And when appropriate, may I briefly address bond?
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Preliminary examination in person, June 17th, 2025. 12 noon. That's before me. Yes, that's the bond.
As to bond, Your Honor, Ms. Keys did have a no-go to an address located on East Michigan Ave. It is an address that she does have a lease at. The purpose for that no-go to was because the complaining witness was moving out of that residence at that time. From my conversation with APA Zenda, it's been indicated to me that the complaining witness now has fully moved out, has her animals, has no reason to return that address. Ms. Keys is the only person on that lease, so I'll be asking that that no-go to order be lifted so she can return to that apartment.
Response.
Your Honor, we would have no objection. We did get confirmation that she has been out of the address for some time, so she would not be residing there or returning.
So I will delete the no-go to provision. Okay. Very good.
Thank you, Your Honor.
Thank you.
Otherwise, bond will continue with its conditions.
Thank you.
Court does call the case People versus Demario Farrell.
Elliot on behalf of the people, Your Honor.
Your Honor, Mike, yeah, I'm Public Defender on behalf of Mr. Farrell. State your name, Mr. Farrell. Farrell. Your Honor, at this time, we'd ask the court to set this matter for preliminary exam.
All right. Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Judge, if I could be heard on bond.
Yes, preliminary examination in person will be set June 17th, 2025, 9 a.m. That is before Judge Moore. Yes.
Judge, Mr. Farrell is here. Obviously, he's in custody. We're asking that the court maybe consider reducing his bond and giving him a GPS tether. He does have a local address. There's an address that I can give to the court over in Ypsilanti that where his father and grandmother reside, and he may reside there as well. He reports also he did obtain a job in Wixom, and it is a full-time job. He reports that he has been in contact with his boss there, and the job is open for at least for the current period. We'd ask the court that the court give him an opportunity to reside outside the jail, either by reducing his bond to a postable number or a personal bond with the GPS tether, and any testing requirements and no go-to requirements that the court deems fit to ensure both the safety of the public and his appearance. And the address on Kirk Street in Ipsy is not an address where the complaining witness resides.
So the address you were referring to is the Kirk Street address?
Yes, Judge.
Thank you.
Your Honor, I'm going to object to modification of bond. This case is a reauthorization of existing
Sure.
matter before Your Honor.
Sure.
I have concerns, given that in that case, which he failed to appear back in 2023, did not come back into contact with law enforcement until May of this year, and he was picked up. And at the time that he failed to appear, he had a violation of bond for leaving the state, and also for contacting the victim after he had been released. I have concerns, given that there were concerns of previous contact, and that he failed to appear for over a year and had left the state. So I would ask that bond remain the same in this case, Your Honor.
Your Honor, Mr. Farrell is well aware of the importance of this matter, and I would note that he's now charged with a felony. It's a brand new case. This case has been kicking around for I don't know how long. I don't know why it was never charged as a felony back then, but it is now. I'd ask the court for a personal bond or a reduction.
That's the state.
That is my end. That's what I'm informed by the people.
Yeah. Motion for bond reduction or modification is denied. Bond will continue.
Thank you, Your Honor.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good morning, Your Honor. My name is Alexander Cronin. How are you, sir?
Good. Thank you.
And Your Honor, I apologize. I was just emailing about this case. It is going to be a request for an adjournment due to some discovery, as well as continuing discussions with the people about potential resolution.
June 26, 2025, 9/8. Bond continue.
Thank you, Your Honor.
That's called the case of the people versus Alua Gillis.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Ms. Gillis, who approaches. Ms. Gillis, can you please state your name for the record?
Alua Gillis.
Request a forensic evaluation.
We are, Your Honor.
Forensic evaluation will be ordered. I'll set a competency hearing for August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case people versus Shelby Lawson.
Your Honor, Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Ms. Lawson. Ms. Lawson, could you state your name for the court?
Shelby Lawson.
Really supervising. No, I'm just kidding. just thought I'd ask. Go ahead.
Your Honor, we're going to be requesting to adjourn Ms. Lawson's case. We're still awaiting some discussion.
Thank you, Your Honor. So as I mentioned to the court, I am asking that Mr. Johnston be allowed to be released to inpatient treatment. That is a priority of his. He acknowledges the issues he has with substance use, and he is eager to get treatment. I know Mr. Johnston is not happy about my request for an adjournment of the PCC, but I think it's important because I do think there is some additional discovery that we should see before he makes a decision whether or not to waive his exams.
Adjourn probable cause conference June 26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. I did just want to briefly address my question, please.
Yes.
We did discuss this at the bench. I understand that at our last hearing, the court was very clear with Mr. Johnson about the fact that there was no contact with the DV victim related to this other case, and who's also involved in this case as well. And his phone privileges were revoked at the jail, and that he was having absolutely no contact with her whatsoever, including third parties. Since that time, we do have a report and transcripts from some calls apparently made with other people's pens, and he has contacted third parties. Well, he's attempted to call her 6 times, and also use third parties to make requests that they get in contact with that same victim. So tell her that he loves her. I can make a further record of some of the comments, but Mr. Johnston is apparently under the impression that because he had and still has consensual contact with her in his other case, that trumps any orders given by this court. I would ask that the court make it very clear, since in one of those calls he stated that the county, quote, fucked up his orders. And I won't repeat the comment that he made about Your Honor, apparently in this case, but,
I'm sure it was very affectionate, so go ahead.
Sure. Affectionate with all the F's. So he, Mr. Johnston, is under the impression that, again, there are erroneous orders made. I would like the court to be very clear with him that no matter what order he has in any other case, a revocation of phone privileges, as well as no contact with this victim, including third parties, regardless of this location, including should he be released to inpatient treatment, as counsel's order states, all prior bond conditions remain in full force and effect. That does include contacting this victim, including with third parties. While we may not have a recording from him while he's in treatment, it will still be apparent to us because, quite frankly, Mr. Johnson has been anything but subtle since he's been having this case pending. So I'm just asking for a reminder of those conditions. And I don't have any issue with the release of treatment. However, I would ask, well, I'll just leave it at that. I'm asking the court for now.
Thank you. I just received the transcript of these calls, actually, just very brief, not too long ago this morning. I am going to have a very detailed and thorough meeting with Mr. Johnson later today about his bond conditions. He does have two different cases. Obviously, she's not listed as a victim. In this case, it's the circuit court case where she's the victim. And so I will make it very clear with Mr. Johnson in our meeting later today. I will, and I would request the actual calls from the state instead of just the transcript.
Mr. Johnson, you understood what I ordered? Not asking whether you like it or not. You understood what I ordered?
I kind of understood, Your Honor.
Yeah. What's the kinda?
I've never been in like court like this before, so I'm new to this, like being in trouble and stuff like that. So I'm not all familiar with the terms or wording and ways of effect of. I watch a lot of court TV, yes, but I don't understand personally, no. I do have like a question of like what does a no contact order mean, Your Honor? Like, if you can, like,
No contact order means that you are not to have contact with that named individual, either directly or indirectly through third parties in any way whatsoever. You are not to have contact via any electronic communication, whether it be telephone, email, social media, or anything like that. And you are also not to mention them on any social media platform. Is that clear enough for you?
yes, Your Honor.
And understand something. I don't believe in coincidence. So if there's contact, I'm going to believe that you purposely did it, either yourself or through some third party. Because even after I ordered it the last time, and I don't think you don't know as much as you're trying to pretend before me that you don't know, because of some of the stuff that you were saying going out of the courtroom. Also, if true, your behavior indicates that you are sophisticated enough to get somebody else's pen to try to make communication in an indirect fashion. So you understood exactly what I said. You just didn't like it. So hopefully now you do understand. Do you?
Yes, sir.
Do you have any other questions regarding what I mean by no contact?
No, Your Honor.
I don't want to hear any more that there is any type of use of somebody else's pen to do some direct or indirect contact with the victim, because you're not supposed to be making phone calls at all. You've lost that privilege. Anything else from either side? June 26, 2025, 9 a.m.
Your Honor, would the court consider a 1-week adjournment, or is that not enough time?
If you want, if that'll work for you. If you're trying to get I don't know about the discovery. That's the only thing I'm trying to.
Understood. Do you know?
I'll give you the 1 week.
Okay.
The 911 public problem.
June 12th, 2025,
Thank you.
9 a.m. Bond is continued with its condition and my admonition that you need to follow what I order. Thank you. Have a good day. Court calls the case, People versus DeAndre Cersei.
Hey, Richard. Oh, I'm sorry. I'm so sorry.
Evan R. Terry requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of APA Rachel McDuffie, Your Honor.
He was here on Tuesday.
Yes, Your Honor.
And when he was trying to make the actual prosecutor run out to find somebody, he was sitting here and he was doing absolutely nothing. He didn't even step up to say, can I help? And can I go out? He just did nothing. He just sat there. You remember? You do? And then I said, you go. And then he went. And you know what? He didn't even come back with the person. I don't know what he was doing out there. He just kind of sauntered back in. I don't know. But nevertheless, permission to practice is granted.
Evan R. Terry for the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cersei.
Can you state your name?
DeAndre Cersei.
Thank you, sir. You're looking for an adjournment?
Yes, Your Honor, we're looking for an adjournment to continue negotiations with the people.
For the 17th or 26th? I
26. Yeah.
Ow.
June 26th would be fine, Your Honor.
I knew you'd take that. And the only reason I gave Bukovich a choice, because last Thursday, I don't really feel sorry for people, really. I feel sorry for him. I really did. I mean, he was so confused. He was giving it, pointed toward the door. Just turned his back on us. It's okay. I'm a forgiving person.
Thank you, Your Honor.
You don't mean that. Probable cause June 26, 2025, 9 a.m. Bond will continue. Thank you, Mr. Susan. Let's call the case, People versus Chad Jones. That is my last one.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Jones, who's approaching. Mr. Jones, can you say your name for the court?
Chad Jones.
Your Honor, there is a pattern with me this morning. I'm asking for Mr. Jones to be released to treatment. I do have a proposed order. I did discuss this with Ms. Douglas, and I don't believe she has an objection. Sorry. The issue, may I hand an order, proposed order to Ms. Douglas?
Can you? I don't know. Yeah, go ahead.
Mr. Jones does have several holds, including 2 holds that are bond denied. However, I have been in touch with his attorney in his Wayne County case, where he's going to try to get him released to treatment with a tether in the Wayne County case. And obviously, he's not going to be released from here until he deals with those 2 holds anyways. But we are trying to get the ball rolling. And I just am realizing, and I apologize, Your Honor, I did not put a tether in this order. And that is one thing that Ms. Douglas and I discussed. So I apologize. I can revise it.
And that was going to be on a GPS tether.
I don't have objection to release to treatment. If there's a tether, I do think that would be Mr. Jones.
I'll just insert it after available. I'll insert with GPS prior to release.
Thank you, Your Honor.
All right.
And I should have given this. I'm sorry. And I am asking for an adjournment of the PCC for continued discussion about resolution, global resolution, as Mr. Jones has multiple cases.
Yes, he does. June 17th, 2025, 9 a.m. Bond will continue. I signed the order.
Thank you, Your Honor.
All right. But court does call the case, People versus Sterling Pierce.
Allyson, on behalf of the people, Your Honor.
Good morning. Once again, Your Honor. Wendy Burnwell on behalf of Mr. Sterling Paris.
Sterling Pierce, sir. Thank you.
Your Honor, maybe briefly approach.
Again? Okay, okay. In this matter, we have an amended complaint which adds counts 4 and 5. Counsel, you received a copy of that, Ms. Barnes?
Yes, Judge.
And you waive any formal reading of that?
Yes, Judge.
And your plan stands to meet to those charges?
That is correct. For the increase in your charge to.
What's the max years?
Hmm?
What's the max years? All right.
We gotta do the.
So taking care of that part. Also, just because of the counting of the counts, at this time, the people are moving to dismiss count 3.
Correct, Your Honor.
There's no objection from defense. Dismiss count 3.
Come talk to me tomorrow.
Yes.
And then you're requesting a forensic evaluation.
Yes, Judge, I am.
All right. Forensic evaluation is ordered. I'll set a competency hearing for August 28th, 2025, 9
If I can address bond.
a.m. Yes, go ahead.
Come to our attention, Your Honor, that the defendant has made 18 complete calls to the victim since being arraigned. In these calls, he first calls his mother, wants to do a throwaway call to connect the victim in, and then eventually gets a hold of the victim. And he's telling her he loves her, he wants to get back together with her. At this time, I'm going to be asking for his phone calls to be revoked because on top of the 18 completed calls, he has 124 total attempts, including those complete calls. So at this time, I'm going to be asking that his phone privileges be revoked.
Yeah, I'd ask that not happen. I think he understands now not to make any calls. I don't want him to be cut off from his family.
Well, he requested a hearing on this, but I mean, after you listen to the calls, but he's supposed to have no contact with him. That's
Your
third number.
And I would have concerns that he's calling his mom and that was going to be called to try to make a three-way call.
Which is going to be also a violation of the bond. And this time, defendant's phone privileges are hereby ordered revoked. In all other respects, his bond will continue. Thank you.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones, who's here to my right, Judge. State your name, Mr. Jones.
What's he doing? You feel better today?
Yes, I do.
Do you?
Yes.
Sobriety is a funny thing, isn't it? Never mind. You don't have to answer that. I'll never show up here like that again. You hear me?
Yeah.
All right. What are we doing?
Oh, I'm sorry.
Oh, I'm sorry. This was also an arraignment. The court was attempting to arraign him on the new case last time.
Right.
Yes, on the 25 F2 1293, Your Honor, or 0697, Your Honor, anticipating that that will be appointed, I would waive reading and standing.
All right. Defendant having waived formal reading standing mute, court will enter a not guilty plea as to that case. And the public defender is appointed in that matter. What date did you want me to set probable cause?
Your Honor, I did receive the police report earlier this morning. Ms. McDuffie was kind enough to send it to me. The version I got last night wouldn't open, so I haven't had a chance to go over that with Mr. Jones. I'd ask for the next available date, and if I could be heard on bond.
Yes.
Your Honor, Mr. Jones is here.
Well, hold on a second. I'll make it the 17th, so he's not.
Thank you, Judge.
June 17th, 2025 at 9. That's time on the other matter too. Go ahead.
Thank you, Judge. Mr. Jones is here in custody today, obviously. He does have a place to reside. He resides in Ann Arbor. He does have his own apartment. He does receive assistance from Avalon Housing. I was able to reach them on the phone, and they are, would continue to provide him assistance in navigating the ins and outs of life. He would comply with whatever drug testing the court would require, where sober link if the court, or scram tether if the court required such. He does receive a monthly, I believe does receive a monthly shot under an ATO. I'd ask the court to give him an opportunity to have a personal recognizance bond in this matter with monitoring and whatever testing requirements that the court deems suitable.
From the people.
Your Honor, while I don't have an issue, my original request was for a $7,500 PR bond on this case. It probably goes without saying, especially at this point, that I am requesting a testing order. I don't know to what extent alcohol is something that Mr. Jones deals with, but certainly drugs, narcotics, cocaine specifically, are of concern to the people. I think that there was a request on his older file, but because he had been hospitalized and gotten out of treatment, the court declined to impose a testing order at that time. Unfortunately, I think we see that we probably need to keep close tabs on Mr. Jones's compliance. Other than that, no objection to the PR and attendance.
Yes. How often are you using it when you're out?
Well, hey, but banging not that much.
Why?
Banging not that much.
Because I was a bit surprised you did what you did last week. No, usually you show up and you show up sober enough to take care of business.
Yeah, I had a lot going on between my mom's girlfriend and the house selling. It's all right. Yep. Yeah.
On case ending in 575. In that case, that I've adjourned to the 17th at 9. I'm going to reinstate his previous bond of the 5,000 personal recognizance. All right, and the previous conditions. It means that you're going to have testing on that. Understood?
Yes, sir. Yes, Your Honor.
On his new matter, I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You need to repeat that?
Oh, yeah.
You sure?
Yes.
I'm going to order that he test at community corrections. How often are you testing under the old order? How many times are they calling you?
Not once.
I don't believe he was
Oh, was it?
at all.
Oh, that's right. So I'm going to order intermediate supervision with at least 2 times per week drug testing. Got that?
Okay.
Thank you.
Your Honor, will he need to report immediately to community corrections if he gets out or within 24 hours? Or will they come see him before?
Yes, they get him out, community, and you're out before 4:30. I want you getting over, or 4 o'clock. I want you getting over there to community corrections.
Yes, Your Honor.
You hear me?
Yes, Your Honor.
Thank you, Your Honor.
All right. Let's call the case, People versus Paris Lester.
Cameron Edish on behalf of Mr. Lester is approaching.
Paris Alexander Lester.
Thank you.
Your Honor, we were going to be asking for an adjournment for a potential local resolution on his other matters.
Probable cause conference, June 17th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Jacqueline Murray.
Cameron Edish on behalf of Miss Murray, who can hear anything there.
Jacqueline Murray.
All right.
Your Honor, we were going to be asking for an adjournment pending for release to treatment, but I believe she's already started her Dawn Farms program in custody. So we'll just be adjourning for plea negotiations after she does some progress there.
After she shows some progress.
Yes. She just started, I believe, right?
Yes.
Is this the only, are these the only cases holding her here? Or does she have other?
She has other cases. I also believe she has cases. Well, she resolved, she has one warrant out of 35th that I don't believe has resolved yet. But here,
Okay, how much time do you want? I mean, I can do the 17th or the 26th.
the 26th, Your Honor. I think
26th.
she'll have more progress at that point.
Yeah, that's what I was,
Thank you.
I guess, kind of getting at. June 26, 2025, 9 a.m. bond continues.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. Court calls the case of the People versus Michael Patterson. Two
Morning,
cases.
Your Honor. Abigail Nyswanger requesting permission to appear MCR 8.120 under the supervision of Laura.
Get that whole thing.
She did? Right through the Wisconsin house. Permission to practice is granted.
Abigail Nyswanger, fourth.
Mike Gaddy, Assistant Public Defender for Mr. Patterson, who's here to my right. State your name, Mr. Patterson.
Michael Lee Patterson.
Right.
Your Honor, we're here for a competency hearing. I did have an opportunity to meet with Mr. Patterson yesterday. We did go over the competency recommendation from the Forensic Center. We don't have any additions or corrections to that competency.
All right. And no other additional evidence.
No, Judge.
Is there any evidence from the people?
No, Judge.
You would stipulate to the report.
Yes, Judge.
Based upon a review of that report, court would find that the defendant is competent to stand trial, would specifically find that he can understand the nature and objects of the proceedings against him and can rationally assist the defense. Therefore, the defendant is deemed competent.
Thank you, Judge.
I'll need orders.
I will prepare an order, Judge.
You ask some good. Okay. And what would you like this set for?
I'd ask to set this for a probable cause, these matters for probable cause, Judge.
Are these the only cases holding him here?
Yeah.
I mean, did you want me to set it the 12th or the 17th? That's, I guess, my ultimate question.
I'll leave that to the court's discretion. I do have a request on this. Actually, I think he has an MDOC hold, Judge.
Does he? Okay. No,
But I think that may be cleared up. I have not been able to verify that.
all right. I'll set probable cause conference for June 17th, 2025.
I wanted to say something to the judge.
All right. As to bond.
Yeah.
I mean, Your Honor, Mr. Patterson is here. He has indicated to me that he would like to seek treatment, most notably at perhaps the Havenwick facility in Auburn Hills. If I'd ask the court to consider if we are able to arrange that, to consider if I'm able to talk to the prosecutor, reviewing a stipulation to release to that treatment if we're able to secure it.
That would be inpatient.
Yes.
Okay. I typically am not going to have an objection to any release to inpatient treatment.
Okay, thank you.
Appropriate, but if you work with the prosecutor. Okay.
So what?
Otherwise, his bond will continue.
Release it.
Okay.
Okay. I'll be in touch, okay?
All right.
Good morning. Attorney on behalf of Mr. Redmond. Your Honor, I had a green sheet. It was there and now it's missing. So I'll get that to you.
Probably why I said that about Yagi.
I know.
All right.
I guess I could admit my own faults.
Your name, sir?
Tyler Redmond.
Thank you.
Your Honor, we are requesting an adjournment for ongoing plea negotiations and a referral to drug courts. So we're going to get them assessed.
That's correct. That's a felony in your report, Your Honor.
Okay, so are you going to be doing that referral? I mean, I'm just thinking in timing of the adjournment.
Ms. Lonnie may know better than I. Do you know how long those assessments are taking?
Right now, I don't, but I would say if we could do 2, and if it's not done, we could do a sipping order.
Yeah, that works for me.
All right. Then why don't I just try the 17th to start with, and let's see if we can get it moving. Probable cause conference, June 7th. Bless you. June 17th, 2025. 9 a.m. Bond will continue.
Thank you.
Thank you. Thank you, sir.
Mike Gaddy, Assistant Public Defender with Ms. Roberts, who's here to my right.
Yeah, Makita Roberts.
All right.
Your Honor, in speaking with Ms. Roberts and then in speaking with Ms. McDuffie, while I would like to also discuss a global resolution, it appears that there's a bench warrant that's outstanding out of the circuit court that didn't appear in X jail that Ms. McDuffie had found. It looks like it's a 2020 FTA matter.
That was already over at circuit.
Yeah, it's just an outstanding warrant. I'd ask the court to adjourn this briefly so I can track that down and get everything all squared away.
Okay, June 17th, 2025.
Thank you, Judge.
9 a.m. Bond will.
I'll be in touch, okay?
Thank you, Mr. Roberts.
Thank you, Your Honor.
What's your name, sir?
Mr. Washington.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing within on behalf of Mr. Washington. Today's the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination. We do believe all of the discovery is present.
Your Honor, I was just telling Mr. Brown, I didn't get a chance to tell him that I checked in advance with the OIC regarding availability. And he stated that he could be available either next week, June 10th, or July 8th. He will be out the, intervening 3 Tuesdays.
Dude. Yeah, I can set it.
It's just supposed to be $10.
Everybody's gonna be ready.
But she charged the whole man tax too.
Okay, so we'll work on this. So July 8th was one of the options, Your Honor.
Yes,
And what was the other?
it was June 10th. It was, yeah, this Tuesday coming up.
June 10th, please. Your
June
Honor.
10th?
Yes, please.
Okay, everybody be ready on that day. June 10th, 2025. 9 AM, that will be before Judge.
I don't want to adjourn.
That's before,
No.
that's before Judge Barr.
Available PE, but not sure that's the next day.
All right.
I just want to check the council, are we sure about June 10th?
Yes.
Okay.
Yeah, adjournment will be July 8th. We ain't trying to do that.
No, well, no, adjournment.
You want June 10th, right?
Yeah,
See?
that's preliminary. Okay, cool.
That works. That's pretty.
You two all set?
Kind of. We're getting there.
Kinda, no,
Baby.
I ain't got all day.
Try to figure it out. Try to figure it out, Simpson.
June 10th, 9 AM before Judge Barr. Bond will continue. Thank you.
Thank you.